Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable J.P. Cohen, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Well, good morning. Welcome to a oral argument session of the 5th District Court of Appeal. I'm Judge Cohen, as introduced. To my right, Carrie Evander, Judge Evander. To my left, Judge Jim Edwards, newly appointed to our court. We have 4 cases on the docket this morning. 3 of them are civil cases. 1 is a criminal case. The civil cases will be allowed 20 minutes per side. The criminal case, 15 minutes per side. If you would like rebuttal, please indicate how much time you'd like, and I'll be glad to attempt to accommodate that. If anyone has any electronic devices, phones, anything that's going to potentially interrupt the oral arguments, if you could put those on silence, I know that the litigants would be appreciative of that. So, first case on the docket, Maytum versus State. Good morning, Mr. President.
Good morning, Your Honor. May it please the court, my name is William Pinnell and I represent Andrew Maytum, the appellant in this case. Please reserve 4 minutes of my time for rebuttal. This court should reverse Mr. Maytum's convictions for 2 reasons. 1, the prosecutor made several misstatements of law during closing argument that effectively negated Mr. Maytum's sole defense of good faith. And 2, that the trial court erred by failing to instruct the jury on the defense of good faith on grand theft as alleged in count 2 of the information.
Had that instruction been requested on that charge?
Your Honor, I believe the record supports the claim that it was requested.
Where does the record support that claim?
I would point to volume 6 of the record at page 547, where trial counsel says, following discussion of the good faith defense during the charge conference, says you got to put in attempted burglary and everything else as well. Again, page 547 of the trial transcript. The judge responds, yeah, it goes everything. But subsequently...
That's what you call requesting it? That's it? And so when it wasn't given on the grand theft, was there an objection? Was there something saying to the trial court, wait a minute, Judge, you indicated you would give this, but you didn't?
The answer to your first question, I think the record supports that it was requested. I agree with the court that it was not objected to later after the instructions were provided. That's clear from the record. There was no objection to its omission later.
Isn't that colloquy there just about the amendment to what was first going to be given? In other words, that the amendment needed to be thrown in to the standard, if you will, for each place that the instruction had been requested, which was burglary, attempted burglary, and trespass?
I think the colloquy is a little unclear. I think it supports the conclusion that it was asked to be included in everything, but it could be clearer. I would point out the fact that there wasn't a subsequent discussion at all about count 2, so it's our position that when he says everything else as well, it means both offenses. But I agree it could be clearer. It's our position that even if it wasn't requested, that it's fundamental error not to include it in this case.
Does it make a difference that the jury obviously rejected that defense in terms of the burglary charge?
I think it could in a particular case. I think it does not in this case, given the repeated misstatements of law made by the prosecutor on the good faith defense. So in this case, I do not think, Your Honor, that it does. Again, I think the record clearly reflects that there was 3 separate misstatements of law on the good faith defense by the prosecutor, who's an officer of the court and who should not be contradicting the clear law provided by the judge in the jury instructions, and that's what happened here on 3 separate occasions.
But didn't the jury instruct, or didn't the judge instruct the jury that what the lawyers said isn't evidence and it's not the law?
Your Honor, the judge did. I don't think that curative instruction is either responsive to the objection or sufficient to cure the prejudice. The objection wasn't that the prosecutor was stating facts, not in evidence. The objection was a misstatement of the law. So when the judge tells the jury what the prosecutor says is not evidence, that doesn't cure the misstatement of law. It's not responsive and doesn't cure the prejudice, because it doesn't inform the jury that what he just said to the jury directly contradicts what the law is. So it's not sufficient to cure the prejudice to Mr. Maytum in this case. And again, this is his sole defense, good faith, that he had a good faith belief that he could enter the home. And
And that was based upon what a police officer had told him?
it was based on two things, Your Honor. It was based on, one, the fact that he was listed as a named defendant in a foreclosure notice that both him...
That doesn't make a difference. He wasn't an owner of the house. He had quit claimed the deed over to her. The fact that he's a party to a lawsuit doesn't give him any ownership interest. So it would be based upon the fact that some detective apparently had told him it was fine to go in?
It is based on the detective's advice, but I respectfully disagree with the court. I think when he receives a foreclosure notice with his name on it, which indicates explicitly that he's a named defendant, the second named defendant, on page 2 of Exhibit 8, it says that he's responsible for over $400,000 of debt. I think that gives him a good faith belief that he may be responsible.
Well, let me ask you this. Was he on the mortgage?
He was not on the mortgage.
Okay. Well, you know, if you had sued, Mr. Maytum for attorney's fees owed from some prior case, and you'd gotten a judgment against him for $10,000, whatever, you'd be a named defendant in the foreclosure case. I mean, that would mean you were an owner of the property, right? Or had an ownership interest in the property. But you'd be a named defendant in the mortgage foreclosure. So the fact that if he's not on the mortgage and doesn't have a property interest, it's hard to see where he'd have any legal claim to go on the property, based solely on being a defendant in a mortgage foreclosure case.
Your Honor, we're here today. We're not here today determining whether he should have gotten the good faith instruction or not. The judge gave him that good faith instruction. That was his defense.
Well, it does go to your argument that the prosecutor made misstatements.
Well, I think the case law suggests that he did. I think that it's separate. I don't think the law says it's separate, that a quitclaim deed and any potential liability on a mortgage or note are two separate and distinct interests.
Right, but if he's not on the mortgage, and he's not on the deed, then he doesn't have a financial interest.
But at the point he gets the notice, he believes he's not on the mortgage, but the bank apparently does not believe that. So at that point, he has a legitimate expectation that he's liable for that money.
Right, but you have two arguments. I mean, you've made two arguments in your brief. One is that the trial judge erred not giving a good faith instruction on the grand theft charge.
Correct.
So I understand that, but you also have an argument that the prosecutor made misstatements, including saying that he didn't have a financial interest. Well, I don't see where he has a financial interest based on the record reflected. He's not on the mortgage, he's not on the deed, he gave a quitclaim interest, he doesn't divorce decree, etc. So I'm trying to find how that's a misstatement.
And hadn't he just emailed his ex-wife within a few weeks before the arrest, asking her or suggesting to her that he may go over, and her response was no?
He did ask for permission. Her response, I don't know if there was an explicit no, but there certainly wasn't permission in the email. I would agree with that. Back to but he doesn't have to be correct about his belief. He just has to have a good faith belief under the law.
I understand. My question to you is based solely on your argument that the prosecutor made a misrepresentation of the law, and I'm trying to figure out what the misrepresentation of the law is when the prosecutor says he had no financial interest in it.
Your Honor, he says, as to the quitclaim deed, the prosecutor says, ladies and gentlemen, when he signed his quitclaim deed, he not only gave up his possessory interest in the property, he gave up his financial interest. He gave up any future interest he may have. In context of the good faith exception and the fact that he got notice of this foreclosure thing where he's a named defendant, where they were trying to recover $400,000 against him, The issue of the quitclaim deed and the liability on the mortgage are separate, and the prosecutor is misleading the jury to argue that there is no good faith based on this quitclaim deed when we have this separate lawsuit. So it's a misleading statement of law based on the Jones case from the 2nd DCA and the Sims case from the 3rd DCA, and that was objected to. And the court gave a curative instruction. The state doesn't cite a single case in their brief refuting the claim that it's a misstatement of law. They simply...
Did he have a financial interest in the property? As, standing here today making your argument.
I would probably agree he does not, but I would also argue when you get a foreclosure notice where you're the second named defendant, that you would have a good faith belief.
Well, I understand the good faith belief argument, but you argued that it is a misstatement of law, but you just stated that that's a correct statement.
But they're arguing about good faith in closing argument, and the prosecutor is misleading the jury about that. But I'll move on to the second one. The prosecutor argues that the divorce decree also divested him of a financial interest. It's because on this document that he signed, he gave up rights to the house in Kissimmee, and specifically gave up any responsibility for negative equity. You also know that he no longer had financial interest for liabilities in the house because he signed that all away. With his knowledge, he signed it all away. Again, it's misleading and legally inaccurate based on the Firestone case, which says a divorce judgment or decree establishes the responsibility between the husband and the wife for the debts, but does not affect the interests of external creditors like the bank in this case.
But Counselor, he was not on the mortgage. The divorce decree couldn't put him on the mortgage. He was not on the mortgage. So the divorce decree said, if you had any responsibility as between husband and wife, it's all on the wife. He's not on the mortgage. If he were on the mortgage, I understand what you're saying. And that would make more sense and would concern me more, but he's not on the mortgage, so if you take that together, I mean, if somebody stood up and go, divorce decree doesn't matter, he's not on the mortgage anyway.
I understand, and that would have been subject to the litigation in the foreclosure action, but once he gets that notice, now he has the good faith belief, and I think the prosecutor...
But you're saying the prosecutor misstated the law. I mean, the law and the facts are, he was not financially obligated by the mortgage, by any order, by ownership, or anything else. So if he misstated the law, if you consider it a mixed statement of law and facts, he was correct in his mixed statement of law and facts, wasn't he?
If you took it in a vacuum, but I think it ignores the fact that he got this foreclosure notice and seeks to impugn the defendant for not having good faith based on this divorce decree. So I think the prosecutor is leaving out that fact and making a misstatement of law in the process based on the Firestone case.
There was no motion for mistrial, was there?
Not on that one. On the first issue, there was a motion, there was an objection, and a curative instruction. So I believe that the first objection was probably preserved, and the second two were not. And that this court should consider all three based on a Cherie's case.
You're into your rebuttal time.
Thank you, Your Honor. I'll reserve the remaining time for my rebuttal.
Good morning, Your Honors, and may it please the Court. My name is Marjorie Vincent Tripp, and I'm appearing on behalf of the state of Florida. Essentially, this case is about whether or not this defendant, this appellant, had a good faith belief based on receiving that foreclosure notice that he could enter the property, which is the first issue I'd like to...
He also had communications from a detective who, by the way, if I ever want to commit a crime, I want to get his advice as well, but... So he's got some detective that gives him advice that he can go into the house, right?
There was testimony from the appellant, yes, that he spoke to a sheriff's deputy, and the deputy said, yes, you can go into the house and remove the items.
Okay. So it's not just, so he's got two aspects of the good faith.
Right, correct, but I'd like to cite to one of the cases the appellant brought up in his case, which distinguishes the circumstances of this particular instance. I believe it was the Aversano case, and in that case, the appellant had actually spoken to an attorney and asked the attorney, hey, I'm holding on to these items for this individual, they have not picked them up, what should I do? The attorney first recommended that she send a registered letter, which she did based on the attorney's advice. The attorney also said when she didn't receive any response to that letter, go ahead and send the letter or have it served by a processor server, which she did. The attorney also advised her, if you don't hear from the individual by the date stated in the letter, you can remove or sell the items, which she did. Her defense at trial was not only good faith, but advice of counsel. And the court in that case held that it was ineffective assistance of counsel based on the record, on the face of the record, not to ask for those defense's instructions, because the evidence, number one, was undisputed that she had in fact relied on counsel and had a good faith and honest belief that she could sell the items. That wasn't offered in this case. There was an abundance of evidence contrary to the defendant's claim that he had a good faith belief based on the foreclosure notice. And that's probably why the jury, number one, rejected the fact that he had a good faith, honest belief that he could enter the property, and also found him guilty of theft because they probably believed that based on the lack of a good faith defense with respect to the burglary, that he did in fact have an intent to commit a theft when he entered the home. So even though the defendant testified that, or the appellant testified that, yes, a deputy told me and gave me permission to go in, it still didn't negate all the other evidence that was elicited at trial that supported that this was either a dishonest belief or a pretense, as the state argued below.
Well, let me ask you this, assuming, and I'm not saying it's the case, but assuming that there had been a specific request to have the good faith defense instruction given on the theft count as well as the burglary count, should it have been given?
No. To begin with, the good faith defense was offered as a defense with respect to the entering of the property. So there really wasn't an aspect of entering in the theft offense. So no, the judge would not have erred in refusing or abused his discretion in refusing to give that instruction. And also, I'd like to point out that
That were taken were fixtures?
some were fixtures. For example, I believe there was a built-in microwave, there was a bar or a grill that was testified to that was built in. The others, which are listed in the property evidence items that were submitted to the court below, there were an abundance of other items that included personal items that belonged to his ex-wife. So they weren't all just fixtures. But again, with respect to the good faith defense pertaining to the grand theft instruction,
What would be the purpose of going in the house, then? As far as, he had a good faith defense instruction given as to the burglary count, and I assume that was based on his contention that he could go in to protect his financial interests. So, if he is, are you saying it would be okay, assuming his good faith exception, prevailed, it'd be okay for him to go in the house, but not okay for him to remove anything from the house?
it wouldn't be okay with respect to entering the house or removing items. With respect to the items in the home, the foreclosure notice and the mortgage essentially is a lien on the property, the real estate itself, so that has nothing to do with the personal items that are within the home.
Homeowner can take fixtures, get served with a foreclosure, you can wipe out all the fixtures in the home? Is that what you're suggesting?
No, not at all, Your Honor, and I apologize if I gave that perception. Not at all. In fact, there was some testimony, I believe, in the trial below or discussion with the court that the fixtures, and the appellant had brought up some discussion that there might be an intent to, or a responsibility to protect the property. And if you remove fixtures, that would negate your statement that you're trying to protect the property by doing that. So no, I'm not applying that at all. But with respect to the grand theft and the good faith defense, there was a lot of evidence that displayed that just did not apply in this case. Number one, there was the divorce decree, which specifically awarded the wife the items in the home, and not only the home itself, but the items in the home.
Entitled to the defense if there's any evidence to support it. And he testified that he talked to a deputy, and the deputy advised him that it was okay for him to go in. I mean, wouldn't that be enough evidence to get the instruction?
If he had requested the instruction, the court would not have been in error or abused his discretion in giving the instruction. But the fact that, number one, it was not requested and there was no objection to it, and number two, the facts in support of the defense with respect to the grand theft charge was extremely weak. There was evidence, again, the property division, which he was aware of and signed and executed, that specifically gave the wife the property inside the home. The email from the wife where he asked a month before the theft if he could remove items from the home before the bank gets it, and his ex-wife specifically told him, no, I have someone selling these items for me, so leave them there.
Like you're making a harmless error argument here.
No, I'm arguing, Your Honor, that there was more evidence not supporting good faith with respect to the grand thefts than there was in support.
The standard, if there's any evidence to support the instruction, he's entitled to it.
If there is,
It's not a weighing, there's more evidence that supports the fact that this is, kind of a ruse, as opposed to that there's legitimacy to it. That's not what the standard is.
Your Honor, first of all, it wasn't requested in this case. If he had requested it and the judge had decided to go ahead and give the instruction, there would not have been an abuse of discretion in that case. However, it wasn't requested. Number one, there was no objection either to the omission of the instruction. The court asked after the jury was instructed if there was any issue with respect to the instructions as they were given. There was no objection. There was no notice to the judge that this defense was supposed to also apply to the good faith, to the grand theft charge. And also, Your Honor, because of the fact that there was no objection in this case, the Socor case, which we cited in our brief, specifically requires that if there's no objection, then the defendant cannot claim fundamental error in this case. And we believe that strictly applies in this case and precludes any challenge to the failure to give this instruction. But with respect to the, we'd like to also note that with respect to the burglary count, Your Honor, if you look at the totality of the circumstances, the cumulative effect of the statements that the appellant alleges deprived him of a fair trial, that just isn't present in this case. There was sufficient evidence which negated his claim of good faith defense in this case, and we would ask, unless the court has further questions, we would ask that this court affirm the judgment below.
Thank you, counsel.
Please the court. The court's correct. We're not talking about sufficiency evidence or harmless error when we're arguing misstatements of law or improper omission of instructions, so I think that's irrelevant to the discussion here today. The third misstatement of law, which I think is important to the court's analysis, is where the prosecutor says, that's what the law says. The law does not say if you made a mistaken fact, if you had a mistaken belief. And that's on page 600 of the transcript. In fact, that's exactly what the law says. If you made a mistaken fact, if you had a mistaken belief, that's good faith. And the prosecutor said the exact opposite to the jury and confused them and misled them, and that's improper. And given the facts of this case and the other misstatements...
What's the next sentence?
The next sentence is, it seems to correct it, but it's confusing. This is a confusing case and a confusing legal standard for the jury. The next sentence is, but if the belief is of good faith basis and honest, then yes, he didn't commit a burglary. So the jury's left with contradictory statements from this officer of the court. A prosecutor is supposed to know the law, who's supposed to be not just seeking convictions, but trying to seek justice, and making contradictory statements about what the law is. So that's a problem, and I think with the facts and the other misstatements supports a finding that there's fundamental error.
If, however, counsel's statement was confusing to the jury, wasn't the good faith instruction read to the jury 3 times for burglary, attempted burglary, and trespass?
It was, Your Honor.
And I'm not trying to minimize that, but if there were confusion, they heard it correctly at least 3 times.
Well, yeah, but now they've heard it from the judge one way, and they've heard it from the prosecutor the other way, so they don't know what to believe.
Please.
I don't
know how you can make that argument. I mean, the jury is specifically instructed that the judge instructs as to the law, and what the lawyers say is not the law. And, we take that seriously, and I think the juries take that seriously. When they're given that instruction, they follow that instruction, and for you to suggest that they just blow that off and that they don't know what to do is disingenuous.
I respectfully disagree. I think the prosecutor has a duty to properly state the law and not to contradict the instructions, and the case law says it's improper. So although I take the instructions seriously and I commend the jury for doing their job, I still think it's an issue, and I respectfully disagree with Your Honor. Okay. As far as the argument that the good faith defense was weak, I disagree. The evidence shows that he was cooperative with the police after, that he kept his property, and some of this property was purchased as marital property when they were married, including the barbecue grill. He kept his property at his home in a storage facility. There's no evidence he sold it or transferred it, so the good faith argument here was not a weak argument. He met with...
Counsel, your time is up.
I think based on the arguments in the briefs that the court should reverse both convictions. Thank you.